Hi everyone, my name is Jerry Wagasha. I'm a principal associate at Anjawala and Khanna Advocates in Nairobi. I'm in the corporate department, and today I'm going to be taking you through preparing for completion. This talk is part of a series of talks that will look at preparing for completion, the D-Day to completion, and Binding. This talk will only look at preparing for completion. Hand to your seats. What is completion? Completion is the point at which the necessary formalities for concluding the transaction can be performed by all the principal parties in order to conclude the transaction. What we're saying is that at the stage of completion, all your completion deliverables are ready or in agreed form or have been waived, and the parties are ready to conclude the matter. Exchange or signing. What is the difference? Exchange is the point at which the parties formally decide to enter into the agreement. Usually at exchange, the documents that will be signed will be the SPA, the APA, an investment agreement, or a share subscription agreement. Also, the parties will be ready to disclose and give a disclosure letter or give a tax deed in relation to the agreement or any other side letter required in order for the parties to sign and enter into the agreement. At completion, all the conditions precedent that have been stated in your SPA or your investment agreement that need to be fulfilled prior to concluding the transaction will have been prepared and ready to be completed. They may as well have been waived by the parties. The key considerations for any lawyer entering into the exchange part of the transaction will be the signing procedure, the monies, any other thing that needs to be done in order for the transaction document to be signed. How is the transaction document going to be executed? In order to ascertain that, you will need to be sure of what law or legal regime you fall under. Under Section 44 of the Companies Act 2006, as adopted by Kenya in the Companies Act 2015, UK companies are not obliged to use a company seal to execute documents. If the document is to be executed by deed, you can amend the execution clause of the agreement in order to provide for execution by either two authorized signatories, that is two directors and or a director and a company secretary, or by a director of a company with a witness. So this deals with how the SPA is to be signed and if you are falling under signing it by deed or signing it as a simple agreement. Another key consideration on exchange is to ensure that when you are signing the document, it complies with the Articles of Association of the company. So under the articles, who are the authorized signatories? Are they allowed to enter into this type of transaction? Has the sanction of the shareholders been given? Has the board approved the entering into the transaction? Remember, the company secretary cannot bind the company and therefore cannot sign a document on behalf of the company. So you will need to ensure that the directors or two directors even have signed the document correctly. In signing your document, you will need to ensure that it has been properly signed. That will mean checking that every page has been countersigned, that the counterparts have been attested to correctly, and that you can put the document into you can put the different signatures into one whole document that is a signed document. So that deals with exchange. What is the difference between exchange and completion, and why is there a difference? That difference is because of the conditions precedent to the completion that need to be fulfilled either by the purchaser or the seller or both parties in order to ensure that the transaction can be completed. Ideally, it would be better to have simultaneous exchange and completion on the same day. But to deal with that, you can put into your signed SPA gap covenants that limit the ability for one party, mostly the seller, to do or perform actions that will limit the purchaser's ability to transact once completion has occurred. So what you want to ensure is that the seller does not do anything after having signed the document that will therefore mean that when you complete the transaction, you are then, the purchaser is either then liable or has to incur further costs, or there's a material adverse change in the company between signing and completion. Okay? So, why is simultaneous exchange and completion not possible? That is not possible sometimes due to regulatory approvals that need to be obtained, third-party consents, governmental approval, and all of those approvals may take some time, and therefore you want to ensure that you are bound by the agreement, but also that you have time in order to complete the agreement and complete and deliver the completion deliverables, which are the conditions precedent. So what do you do once you've signed? You need to ensure that you have a completion checklist that sets out all the CPs that will need to be delivered either by the seller or the purchaser or by both, and keep a hold of what documents have been signed, what documents are yet to be signed, are they in agreed form yet, in order to track where you are and when completion will be available, will be able to be performed. Mostly this is done, for example, if you're waiting for the approval of the CAK or the Competition Authority of Kenya in order to ensure that your transaction can complete. When you receive that approval, you update your checklist in order to ensure that that is reflected. An example of a sample of a completion checklist is on your screen now, and that will show, for example, the clause and the relevant clause in the signed agreement, the requirement, for example, a board resolution, the party responsible for delivering that requirement, and the status. Has it been in agreed form, the resolution agreed, X to deliver on completion day. As a side note, if a document is to be delivered on the completion day or the date of the completion that has been agreed, you need to ensure that you have at least seen the document to ensure that on the completion date there are no surprises and the document is a document that is ready to, that it can be accepted to the purchaser or the seller. So what things do you need to ensure before completion? Ensure that all the documents that are to be delivered and are delivered in agreed form. So that is making sure that all the documents are documents that you have seen copies of, that have been scanned to you by the purchaser or the seller, depending on who you're acting for, and that you yourself have forwarded agreed form documents to the other side. That you have obtained all the signatures required from your end, or that the signatories will attend the completion meeting. That you know who the signatories are. Do they have the requisite powers to enter into the agreement? Do they have a power of attorney that's been given in the correct form? Has the power of attorney been commissioned or notarized? All of those signing requirements are to ensure that when the document is signed on the completion date, or when you say that you have completed, you're able to ensure that you've completed in the correct manner. It is also important to ensure that the people who are available to sign on completion will be available. If they're coming in just to sign the document, you'll not therefore be able to get them back into the country or back into the meeting room again. So all the documents that you're required to be signed, ensure that you get them signed on or before the date of completion. Also ensure that all the parties have signed the requisite copies of documents. If you have 5 parties to a transaction, it's a good idea to get 8 copies of the document signed so that you can ensure that in the case that one of the documents has not been executed properly, you have backup copies, and then you have a copy to give to every single party to the transaction. Okay. So now that you have the requisite copies of the documents, you know who the signatories are, and you've organized a completion meeting, you also need to ensure that you are sure how the monies or the completion monies will be delivered. As a side note, it is important to note that sometimes at the exchange stage of the transaction, a deposit may be given to the sellers to ensure that they have a kind of sweetener and an assurance that the transaction will be entered into. What happens on completion is that the balance of the purchase price or the consideration under the SPA or the investment agreement is given to the seller. In order to ensure that you can complete, one of the important considerations is to organize prior to the meeting or prior to completion how those monies will be delivered to the seller. Okay? It is worth having early discussions with the bank or the other side's lawyers to ensure that you know how the monies are going to come in, what amount to expect and in what currency, for example, USD or Kenya shillings, and if those amounts correspond to the exchange rate and what you're expecting. You will need to know how long it will take for the funds to be received into your account or into the seller's bank account. If you are holding the funds and are acting for the purchaser, you need to be sure that you can only release the monies when you have a fully executed agreement and you are sure that all the CPs have been completed, not before. If you're acting for the seller, ahead of completion, send the money to the purchaser's lawyers with an undertaking that they will only release the monies on your approval. That way you have some control over when the transaction is completed, and if you're not sure that all the conditions precedent have been met, then you are sure that the monies will not be released and you will not have come back to the sellers. You can also undertake as the purchaser's lawyers to transfer the money once you have received all the completion documents. It is always better to have some kind of control over how the monies are delivered, because once the monies are delivered, then you have no way of getting those monies back if there is some kind of default or if there has been a breach or if you then later discover that completion was not effected in the way that you had anticipated. So, if you're acting for the purchaser, ensure that prior to completion, you are holding the funds and then either transfer the funds to the seller's lawyers with the undertaking that they will not release the monies until you are satisfied that they have received the completion documents, or arrange for the transfer once in receipt of all the completion documents and you have checked those completion documents. If you are holding the funds, confirm with the parties if it should be placed on hold deposit. This applies if you're holding monies for a long period of time and it is a large amount of money, and the interest on that can be accrued for your client. So, having considered the exchange stage of the transaction and having signed your agreement, having listed out your CPs in a completion checklist, having checked that all those CPs have been either agreed, waived, or are in agreed form, then having checked that you have ensured that how the monies are going to be held, having ensured that the transaction, you know who will be the signing party, you are then ready to complete. Thank you.